Good afternoon, I'm Peter Bartinik, a board-certified civil trial lawyer practicing law in Connecticut. I wanted to do a short video today talking about two main points that you should consider before you meet with your lawyer to evaluate whether your fall down case, talk about a fall down, if you've fallen and injured yourself, 2 points to consider whether that fall down case has merit. Many people have a belief that if they fall on someone's property, the mere fact they've fallen on that property means that the owner of the property or the person responsible for the property is legally liable for their harms and losses suffered from the fall. That's not true. In Connecticut, you need to prove that the owner had notice of the defect and that they failed to correct the defect within a reasonable time. But notice is the first point you need to consider to prove. You need to be able to prove that in your case in order to win the case. Was the owner aware of the defect? Perhaps the owner caused the defect. Those are two ways to prove notice. The next thing you have to consider when you evaluate any fall down case is your own conduct. In any fall down case, you need to establish that you were paying attention, that you weren't negligent. Were you wearing proper shoes? Were you diligent? Were you somehow at fault? These are two very important issues. Before you meet with your lawyer, think that through. Think it through before you meet with your lawyer. Analyze why you think the owner of that property knew about the defect and didn't correct it on time, and analyze why you think that you were not responsible for the fall also. I hope this information is useful to you. Have a good afternoon. Bye.